Okay, and so now we're going to get the program started. I'm going to introduce our speaker, Robert Nuddleman. Robert's a local employment law attorney helping employers and employees navigate the intricacies, thank you, of California and federal employment laws. He helps companies, including many nonprofits, stay up to date on changes in the law and advises employers on best practices. A Livermore resident, Robert appreciates the opportunity to help local nonprofit agencies. He's a former board member of TVNPA, and I personally met him when our boys were in the Scouts, and Robert was the assistant scoutmaster. This shows you what a good guy he is. So I'm going to introduce Robert.
Thank you. I'm going to try this without the microphone because I tend to be really loud anyways. If anybody can't hear me, which nobody's ever told me they can't hear me, just let me know. I think it should come across pretty well on the recording anyways. So thank you, Kathy, for the introduction. Thank you for allowing me to do this. I really love presenting about employment law updates. And thank you, Chris and the Bankhead, for hosting it here. We really appreciate the opportunity to be here. And thank you to all of you guys. You guys do so much for our community. It's really important to me that you guys exist, because without you, you guys fill in all those little cracks that just, without you, people would not be served as well. So thank you so much. So we're going to talk about employment law updates. I'll take about an hour or so. We'll leave some time for questions and answers at the end. But if you have a question at any point in time, feel free to jump up, raise your hand, and we can address it at the time. I may put it off till later if I don't know the answers. I like to tell people, I'll just make it up. You'll never know the difference. But hopefully I can answer any of your questions. There have been a lot of different changes in California employment laws and even some federal changes. We're going to talk about some statutes. We're going to talk about some new requirements that are going to happen both from the federal level, et cetera. In different ways, best practices to be able to deal with those. One of the first ones, one of the major one is the Workplace Violence Prevention Plan. Cal OSHA, the state passed a law requiring almost all employers to have a workplace violence prevention plan in place, in writing, and also that requires a certain amount of training that has to be done. OSHA has finally come out with some model plans and some ideas on how to do that, how that's going to work. July 1st was the deadline to actually have the plan in place. I've looked at the model plan from OSHA. It's long and a little bit difficult to follow, but it is comprehensive, so it has all the things that you have to have in there. My office has kind of simplified it a little bit to make it a little bit easier, a little bit more user-friendly. Cal Chamber has some great tools that are available also to create that workplace violence. And again, it applies to almost all employers of any size. Some exceptions, if I think you have less than 10 employees and everybody works remotely, then you don't have to have it. Or if there's less than 10 employees and you're not open to the public at all, you don't have to have it. Also in the healthcare industry, they have their own workplace violence prevention requirements that have been in place for quite some time. There's a number of different documents that have to go along with that workplace violence prevention plan. But the main goal is to educate employees on any specific dangers that are specific to your business or that could be, and also what to do. Is there a reporting plan? Who do we report to? Where do we go? And before you ask, no, just putting up duck as your plan, it's not sufficient. You need to have a little bit more detail. It includes forms such as if there is a workplace violence incident, what do we do? How do we report that? We have to keep a log of that and keep those things. It can be feel onerous to do it, because particularly if you're not familiar with it, but once you've done it, it gets a little bit easier. One of the unique things about the Workplace Violence Prevention Plan is it actually requires employee input. So you have to designate certain people who's responsible for receiving complaints, but you're also supposed to involve the employees. And you also have to do training. In fact, you're supposed to have done the training by July 1st. By the way, OSHA has not determined what the penalties are if you have not done that. And OSHA is probably not going to come knocking on doors saying, let me see your workplace violence prevention plan. But if OSHA ever does come in and do an inspection, they're going to want to take a look at that. Just like they may want to take a look at, hopefully you have, an illness and injury prevention program. COVID-19 prevention plan, all those have been requirements for some time. And if you are in an industry where people may be subject to excessive heat, a plan that also, or at least part of your illness and injury prevention plan that includes the heat awareness. Yes?
How do volunteers versus real employees factor into this calculation of 10 employees or more?
So how do volunteers play into the role of do you have 10 or not? Generally speaking, volunteers are not counted as employees for most things. The problem is what constitutes a volunteer under California law can vary depending on the context in which you're talking about. My recommendation is, I think even if you have 1 or 2 employees, having a workplace violence prevention plan makes sense. It doesn't hurt to have one, and it can help prevent things. Particularly if you are dealing with, if you're in an industry or an occupation where there's some risk of an incident of workplace violence. And workplace violence doesn't necessarily mean somebody got hit or shot at. It can be threats of violence. It can be people feeling unsafe. So I think it's good to have protocols in place on, hey, this is what we do. You know, can I tell a consumer, maybe somebody I serve in the community that is maybe experiencing some issues and behaving in a way that's making people feel uncomfortable, what am I supposed to do? I think it's great to be able to train volunteers on how to do that as well as our employees. Now, on the training, since the policy requires that employees get involved in the creation of the plan, my solution is you create your initial plan and you sit down with the employees, and if you want to include the volunteers, that's fine, and you go through with them and you ask them, is there anything else we can be doing? Are there any dangers that we're not aware of? Or do you guys have any suggestions? That way you're not only getting their impact, but you're doing the training once. You got a question?
Well, just along the same lines, for seasonal workers where there aren't a lot of hours in a year, how does that, for compliance purposes, how do they count that?
So the question is, for seasonal workers, does that change for whether or not the number of employees? I don't believe there's any difference regardless of seasonal or how the length of employment. There might be something in the regulations that say, you know, the employees have to be employed for a certain period of time. But oftentimes the seasonal workers, they're working for a couple months, then they go and then they come back, and I would count those within the 10 employees. And again, it's 10 employees and there's no access, the public's not in there. So most seasonal employees, I always think agriculture, but I suppose there are other seasonal employees too that I'm not thinking about. But it has to be both less than 10 and they're working in a place that's not open. That training that is required, it is an annual training, so it means every year pull that back out. You want to keep a log of everybody that's attended the training. There will be plenty of organizations providing training, which I think is great if you want to bring in somebody from the outside. I think it's also training that is very easily done on your own, of just going through what the plan is, what we should do, and having that conversation with people on how do we protect that situation. There's a lot of debate over why do we need to really have this. Are there that many incidences? Okay, maybe that's a valid debate, but the reality is it's there. So we have to do it. Overall, I do think it's a good idea. It's another way to protect and prevent people from experiencing any injuries or problems. So we talked about that first training, going over that. Subsequent training, if you've had an incident, if there has been a workplace violence incident, then that may be an indication of how do we want to change this? Do we need to modify it? Do we need to do something else that's going to protect us? So do we have to have locked doors? Do we not? Different things to be able to consider. You do have to keep records for 5 years of any incidences. So that's what the log is that you would use. If OSHA comes and asks, you have to provide that. If an employee asks, hey, I want to see your workplace violence log, incident log, you have to also provide that for as well. Yes?
So with the training, so you do it annually, but then if you get, say, new employees along the way, does it just bump to the annual, or is there a certain amount of time that you have to train them within their start date?
Yeah, the question is how, if you have a new employee, how soon do you have to get them trained? Do you have to do it? Can you wait till the next year? I'm gonna say, we don't really know. The regulations, yeah, the regulations, like, compare this to the required sexual harassment prevention training, that if you have 5 or more employees, all of your employees have to have 1 hour of sexual harassment prevention training, and if they're supervisors, they get an extra hour, they get 2 hours. That specifically says they have to get it done, I think it's within 6 months of when they start, or if they've had it done somewhere else, then that will suffice. The workplace violence is a little bit different, because even if I get training at employer A, and I go over to employer B, a new company, different threats may be involved. Couple different options for that. One, you could say, here's our plan, read through it, and let me know if you have any questions. I would probably do that at a semi-minimum. Minimum, I would say is, hey, if you need to look at our workplace violence plan, it's right there. I'm happy to go over it with you. Right next to our illness injury prevention plan and our COVID-19 prevention plan, which, yes, we still have to have COVID-19 prevention plans in place. So they at least know where they are. You can incorporate them all into one giant. You can put your workplace violence prevention plan into the written illness and injury prevention plan. You can keep it as a separate document. It just kind of depends. I kind of like them separate only because that Cal/OSHA model plan is so big. Even for a simple office environment, it can be a sizable document, 30, 40 pages, something like that. Yeah.
When you say 5 or fewer employees or 10 or fewer, do you know if the labor board considers employees, is it FTEs?
No.
Or is it?
Yeah. So the question is, when you're looking at the number of employees, is it full-time equivalents or not? The only one that uses full-time equivalents is the Affordable Care Act, Obamacare, where that one looks at if you have 50 or more full-time equivalents. So if you have 2 people working 20 hours, that's 1 full-time equivalent, that's 1 person. Most of the other laws, the anti-discrimination laws, the workplace violence laws, things like that, just talk about employees. It means part-time, full-time, temporary, all of those.
So we hire seasonally. We're a theater, so if we have actors for 9 weeks, and there's 20 of them, we now have 20 employees.
So,
Awesome.
so what's interesting, like a situation where you have somebody, right, for 9 weeks we have 20 employees, what do we do? So the Fair Employment and Housing Act, which is California's anti-discrimination laws, used to have a very nice, clear-cut definition of counting employees. How many people are on your payroll for any 20 consecutive week period? 6, 7 years ago, they changed the regulations for a very amorphous, do you regularly employ 5 or more employees? And regularly employed is not for any specific period of time. It would include seasonal people. It doesn't have to be specific people. So if it's like, it's not these 9 people who keep coming back. But no, we can pretty much guarantee that every year at some point in time, we're going to have these 9 people. That's going to be regularly employed. Make it even worse. Technically, it's not just employees. It is those who work under a contract, which could mean independent contractors. Well, that's a whole other topic about independent contractors. Some of you may remember back in 2000, the legislature changed the law. They did this AB 5, which essentially made nobody an independent contractor in California, or made it more difficult, particularly for nonprofits and theaters. It was getting a lot of press, and then COVID hit. So then COVID was all the talk and the employment stuff. Now that COVID's subsided, I am starting to see more issues with independent contractors. So that is something to be aware of. Like, are people actually independent contractors? Now, the nice thing about that ABC test that they adopted is they did later in September 2020 modify it, so there are certain exemptions. People who don't fall under that, and there's like 168 different exceptions to the general rule. One of them may apply. It's a little bit easier for them to apply. If you think you have independent contractors, I do encourage you to talk to an employment attorney or an HR consultant familiar with the different regulations to make sure that that's done correctly. I generally recommend if you have people that are working regularly, even if you call them independent contractors, I'd count them as employees for most of the laws, because I'd rather count them and follow the law than not count them and find out, oh, I made a mistake. And the other thing is, the vast majority of those laws that we have to follow are probably things that you're going to do anyway, such as the anti-discrimination laws, which only apply if you have 5 or more employees. You're probably not going to say, well, I was going to not hire you because you're a man, but I don't know, to have 4 or 5 employees, I'm not sure what I should do. So it's a good idea to not make business decisions based on age, race, sex, national. Other big changes, we have some minimum wage updates that have come into play. We actually have a ballot measure coming up, which is going to be interesting. Several years ago, California increased the minimum wage, and as part of that, they increase it every year. So right now, I believe it's $16 an hour. The good news is they used to have a different minimum wage if you have 25 or fewer employees or less than 25 employees. Now at least the minimum wage is the same regardless of the number of employees. The downside is cities, counties have different minimum wages depending on where the work is performed. And now, if you are a fast food worker or in healthcare, you have a different minimum wage, kind of. We think maybe. We're seeing that. I say that, so fast food workers is pretty much set in stone. They have a higher minimum wage. It really only applies if you have like 60, your national chain. You've got 60 or more places. I'm assuming that's nobody here. No, we don't have 60 or more chains. Doesn't apply if you make bread. Go Gavin. Nobody likes my solution of, okay, just get a little bread maker and just call it a day, right? There's been a lot of talk about whether or not this increased minimum wage, and I always forget what it is, $20 an hour, I think, is it good or bad? Does it hurt the economy? Does it help? I don't know. We're in California. We have among the highest minimum wage. We have the highest cost of living, so it kind of makes sense. You figure our minimum wage is $16 an hour. The federal minimum wage is like $7.25. And if you're in certain states, you could use your tips to offset that, to make the difference. So you get $3 an hour as long as you get the other $4.25 in tips, you're fine. You can't do that in California. So it's just something to be aware of. There are some exceptions to that one. The one that might impact some of you or some of the people you work with is the healthcare workers. This was a little bit up in the air. It was set to take effect, and then it got pushed back, and now they're trying to they set some new dates for it. Depending on the type of facility is going to depend on which minimum wage you're going to have. Both of these, well, certainly with the healthcare, but I also believe with the fast food overtime, the other big thing that people forget is it does change who is exempt from overtime. Most employees get overtime after 8 hours in a day or 40 hours in a week. Certain employees that are employed like the executives, administrative, or professionals may get paid, if they get paid a salary that's at least 2 times the state minimum wage and they perform sufficient duties to meet the test, they don't have to get paid overtime. Well, if you're in the healthcare industry, it's 2 times the minimum wage for that facility because it's set by the minimum wage. So it's just something to be aware of if you think you have somebody who's exempt. Because right now, minimum wage, 2 times minimum wage, 16,500 and something, I think. 64,000. Did I say 16,000? Yeah, that would have been nice. That's federal. No, it's not. 64,500? Okay. I was told there would be no math. That's why. I can only take 1/3 of any number, so. Anybody contingency jokes now? There are a lot of different minimum wages in California as far as cities and counties. These are just the kind of the local ones. Emeryville tops out at $19.36. I think they're the highest in the state. Hollywood might be a little bit higher. They keep vying to go who's higher. Emeryville also has the nice distinction that everybody's required to provide paid sick leave. That has gone up this year. Now they're required to get 40 hours or 5 days of paid sick leave per employee in California. Some cities have their own. Emeryville They don't have a higher amount, but you can use paid sick leave for your pets. So that's nice. I can't make this stuff up. Many of these go up July 1st, some of them go up January 1st, so it's just something to always constantly trying to be aware of. That. And it usually depends on, are they working at least 2 hours in one of those cities. There's a couple different websites, the minimum wage trackers, where you can put in the city and you just find it. If you're members of the California Chamber, Cal Chamber, they've got some really nice useful tools where you can pull that up. You can also shoot me an email and I can tell you pretty quickly what those are. There is an upcoming November ballot to raise the minimum wage to $18 an hour. There was some talk about whether or not they could get that off. Could the legislature do it? It's on the ballot. We'll see, whether or not it's going to pass or not. There's also steps in the legislature to create their own minimum, to increase it anyways. I am for getting employees, a decent wage so that they can afford to live. It's hard here, but it's also it's the dog chasing its own tail at one point in time, because then you get the price increases that go along with it. My experience, having traveled somewhat around the world, is just about wherever you go, minimum wage is about the cost of a McDonald's hamburger. I mean, it just seems to be a McDonald's meal. I just found that in Switzerland. I found that in California, Italy. Not a lot of McDonald's in Italy, but that's okay. Another huge, big movement was in the Private Attorney General Act. The Labor Code Private Attorney General Act was a law that was put into, it was passed, going back in history. Remember Governor Davis? He got kicked out of office.
Yeah.
Well, after he got kicked out of office, but before he left, he signed into law the Labor Code Private Attorney General Act. The thought being, there are thousands of statutes in the Labor Code that the California Labor Commissioner has the authority to enforce. But since the state of California doesn't fund the Labor Commissioner to the extent it needs to, a lot of these Labor Code sections do not get enforced. And there was no private right of action for the employees to enforce those. Well, Davis changed that and essentially deputized every single employee in California and allows them to stand in the feet of the Labor Commissioner and sue employers, their own employers, who have violated the law. The problem is, I know this is unusual, nobody would think this, but certain attorneys took advantage of that and the fact that there are very egregious penalties, because the minimum penalty is usually $100 per employee per pay period. So if you have 20 employees and you have one violation and it lasts a year, 1 times 20 times, if you pay once a week, 52, it gets very expensive very quickly. And oftentimes there are little things such as like a missed meal break. If I didn't get my meal break, that's a violation. And the fact that I didn't get paid for that missed meal break, that's another violation. And the fact that that pay didn't show up on my pay stub, that's a third violation. And if I didn't get paid that before my employment ends, that's a fourth violation. That's $400 that can get it. So it gets very outrageous. And there were some slight modifications. The governor, Schwarzenegger, when he came in, he modified it a little bit, took out some of the more egregious things. But it's kind of just been sitting there, and it's kind of the bane of many employers, because it's very easy for an employee to make these allegations, and it's very expensive to defend, and most insurance companies won't cover the cost of defense for these things. They finally came up with some really good modifications to it. The plaintiffs can still get their attorney's fees, and by the way, if you defeat the claim as the employer, you do not get your attorney's fees. But some of the changes are, number one, the way the penalties got distributed, 25% of the penalties went to the employees, 75% went to the state to help fund so the state could do more enforcement. And they've raised millions of dollars, tens of millions of dollars, and the state keeps taking that money away and using it for other purposes. They're not doing any more enforcement, so it's kind of a bummer. But what are you going to do? Now the employee is going to get a slightly greater amount. It's going to be 35%. That's not great for employers, but with the other trade-offs, it makes a lot of sense that they got this passed. It used to be, if I experienced one violation, I could sue you for any violation that anybody else suffered. So if I missed a rest period, I could sue for my missed rest period, and as well as I can sue for everybody else's rest period, but also missed lunch period and inaccurate wage statements and the fact that you didn't have your workers' comp notice put up, well, not notice, but correctly, but all these other smaller violations that even though I never was impacted, I could still sue. I just needed to get my foot in the door. Now, the employee who's the aggrieved employee actually has to experience each of the violations that they're applying. There is now a new right to cure that employees have, which gives you some additional time. There's kind of two different periods in which to do it and times in which to do it. The main thing is, if you ever get notice of, hey, you violated the law, because they do have to send on notice, contact an attorney right away so that we can take steps to try and cure that. They've done some stuff to try and make the Division of Labor Standards Enforcement give them a little bit more strength. I don't think that's going to really happen. The courts did affirm that the new law does affirm that the courts have significant judicial discretion on how to award not just the penalties. They've always had the ability to say, look, we're not going to award $400 million in penalties, we're going to lower that amount. Now the courts actually have discretion to actually limit how that litigation is going to happen. Because this is oftentimes separate from or can be combined with a class action lawsuit, which is very similar but different. Class action lawsuits, the courts have discretion to be able to control the scope of discovery, who's going to do what first, that type of stuff. They didn't have that discretion with PAGA actions, now they do. And then, of course, there's an injunctive relief that they can get to, say, to prevent future harm. The part I really like is that you can do what's called an audit. And if you can show that you have done everything reasonably necessary to try to avoid a problem, then you can cut those penalties down to like 30%, which is a pretty significant deal when we're talking the amount of penalties that are out there. They're not overly hard. There are some best practices. One, once a year, go through your payroll practices. If you have an HR consultant or a law firm, somebody can go down, hey, are we doing things correctly? Or how often are we paying? What's on our pay stubs? Do we have people adequately categorized as exempt versus non-exempt? What's our rest and meal break policies? What other things do we need to do? Doing that audit will help. And then making the changes that are necessary. Training your managers and supervisors. We're now suggesting that all employers with managers or supervisors, you do an annual training that just says, you know what? Make sure employees get the breaks. I don't know what it is about California, but almost every single lawsuit that I have in my employment law, there's an allegation that employees didn't get rest or meal breaks. And I'm not saying employees don't get rest and meal breaks. There are plenty of cases where that's the case. But I gotta believe somebody somewhere has gotten a rest break at some point in time. But nonetheless, there's a lot of these lawsuits because they're easy to allege, difficult to defend, difficult to prove. So training your managers to communicate, hey guys, we want you to take the breaks. I mean, it's not just because the law requires. Nobody can work 8 hours without taking a break at some point in time. So just make sure that they're ready. Great, you're hired. So we're talking about doing that audit, doing the training, making sure that we have compliant policies. I mentioned Cal Chamber before. If anybody's thinking about getting a handbook put together, I am a big fan of the Cal Chamber handbook. I like it. It's fairly inexpensive. You can do it on your own, and I'm confident that it's compliant based on the number of employees you have and where you work. And they update it pretty frequently. So I like that as kind of a base template. It can be sometimes difficult to navigate, but I trust that more than a company that might do national HR stuff, just because they're going to be it's California specific. So make sure your employee handbook's up to date. So the other nice thing that they did, which was helpful, is I mentioned that the pay penalties are per pay period. They've now adjusted that so that if you had a violation and you were paying twice a month, which you could do, and I'm paying every week, it's 52 violations for me and only 24 violations for you. So now the penalties can be adjusted, so it's not just because you did it. There are some modifications to the Federal Fair Labor Standards Act. The Fair Labor Standards Act, that's the federal law. Federal law sets the bare minimums, and then states, counties, cities can be more aggressive if they want. The big difference is on how they look at who is exempt from overtime. For most California employees or employers, this isn't going to impact us because we have a higher requirement. Essentially, they go from having to get 44,000 to 58,000 per year in order to be exempt. Plus, they have to meet the duties test. Again, California, we already have a higher amount, so it's not going to necessarily impact this. Now, federal also has another, what they call a short test. So there's pay this small amount, and you got to meet this longer test, and then you're exempt. They have a short test where they don't look too deeply into it, I guess, where if you're paying a highly compensated. So if you're paying, it was 107, now it's 132,000. So your CEOs and people are getting paid more, which I know all you nonprofits are paying, your $150,000 a year. It makes it a little bit easier. It doesn't mean that they're not exempt if you pay them the lower amount. It just means you have to go through a more detailed test to prove that they have. There were some changes to non-compete agreements in California this year. For the most part, non-compete agreements are unenforceable in California. There's been some certain instances where you can have it, like when you're selling your business, but the days of telling your employees you can't go work for a competitor, you can't do that. There are ways to protect your confidential information, but you can't outright prohibit somebody from working for a competitor. And we believe it is also illegal, unlawful to prohibit employees from soliciting your employees, at least to the extent that the employee's job is to recruit people. We weren't sure about that for a while. It came out of a case 3 years ago, I think, where there was a nurse recruiter, and their job was to recruit nurses. And their agreement said, you cannot recruit any of our employees. And the court said, well, if you say she can't recruit employees, that's what her job is, that's her profession. This is a restraint on trade, so that's going to be unlawful. We don't really know if that's going to be broadened out beyond that scope, but I expect it will. The big difference is here with the new laws is, number one, by it was February 14th, I think, it was Valentine's Day, employers that had non-compete agreements that were invalid needed to send a notice to all of their current and former employees saying, hey guys, we're not going to enforce that illegal provision. Which creates quite a bit of a conundrum, because it's like, you're requiring me to admit that I have this unlawful agreement. So you got most employers that kind of head saying, we're not saying it's illegal, but we don't enforce illegal contracts. So to the extent it's illegal, we won't be enforcing it. The other thing is, the law was always written that that the agreements are void. So if I have a non-compete agreement, it's void. An employer can still try and sue you over it, and they could, they would lose, but you spend time, money, and resources. With this new law, the employee can sue an employer just for having that in their agreement. And they get their attorney's fees, and they can get penalties and things like that. So some companies used to keep the non-compete agreements because even though they were unenforceable, many employees didn't know that, and so it was still effective. Now, if they keep those things in their clauses, they actually can get hit with liability. By the way, this is a separate code section. It's in the Business and Professions Code section. So that Labor Code Private Attorney General Act claim I talked about actually would not impact this at all. Other big difference in the legislature, for Equal Pay Act violations, there's some new, stronger presumptions. It used to be, it's always been illegal to discriminate against somebody or retaliate against somebody who has complained about unfair wages or unequal wages, not unfair. You know, paying men different than women or paying Caucasian people different from African Americans. That's been illegal for quite some time. And it's illegal to retaliate against them. But proving it can be difficult. Now, this new law creates a presumption of retaliation if the person is terminated or suffers some other adverse employment action within 90 days of their complaint. And this is not a complaint just to the government. It can be a complaint to you. So if an employee says, hey, look, I think I'm getting paid less and I think it's because of my gender, I don't agree with that, and then that employee gets terminated or put on a performance improvement plan, it creates a rebuttable presumption, but it still is a presumption that the employee was retaliated against. So it really kind of gives them extra protection for at least that 90-day period. We've had similar 90-day periods in things like in healthcare. If somebody is advocating for patient safety and they get terminated or have an adverse employment consequence with action within 90 days of that report, there's a presumption there. So that's really nothing new. It's just a new area where they're putting this into. I think it gives greater protection. Yeah.
So if somebody thinks they may be getting terminated soon, they could preempt it and complain about their salary?
Yeah, so could an employee theoretically, never would this happen, think, okay, I'm about to get fired because I've just been written up 4 times, I'm going to complain about my wages and have protection. Yeah, they could. This is where best practices come into. And I do a whole series on kind of best practices. The short version is, don't ignore a problem. If an employee is not doing something you want them to do, or doing something you don't want them to do, talk with them about that. And it preferably, if not a written note, make a mental note that you had that conversation. Because if they do it again, then we want to raise that level up a little bit. And we want to say, okay, we just had this conversation 3 weeks ago, told you your start time is 9 o'clock, it's 9:30, this can't happen again, I got to give you a warning. Verbal warning. That you document. They don't have to sign it necessarily, but you want to have something. I had a conversation with Rob. I previously talked to him a month ago because he was half an hour late. I told him he needed to be there. He understood. Told him I was giving him a verbal warning. Next time, if it happens again, now it's a written warning. So we're doing that kind of progressive. There may be some things that we have to jump right to something more serious. Rob, I told you, stop stealing our money. You're not supposed to do that. Maybe that's going to be more than a verbal talking to. Yeah.
I often advise my clients to follow up a verbal conversation with an email, just because that does prove that you did talk to them about whatever minor issue it was, even though it wasn't a formal write-up. It still kind of counts as a write-up. Do you ever have people use emails to strengthen their case?
I love emails, and I hate them.
Oh.
They're great because they create evidence, which is great and bad, because they create evidence. No, they're actually great. And I think there's a couple different ways to do it. It could be an email to the person, hey, thanks for talking with me. This confirms what we talked about. And having it in writing also gives it a little bit more gravitas. You can also do it by sending an email to your manager. Hey, just want to let you know, I talked to Rob today. This is what we discussed. He said he understood. Just want to give you a heads up. You've created that same sort of documentation. If you don't want to send an email, you can write a note, put it on a napkin, do it something so that it's going to be preserved, preferably not a napkin. Really. Just because what we want to be able to do is when we get to that written, we want to be able to say, we had this verbal conversation, we had this verbal warning, we had this, so we're showing that progression. By addressing issues when they come up, by having some documentation, it gives us the basis to say, no, this is not. I had a client, great example, employee complained about mold in the bathroom. Supposedly, my client says he didn't, but the employee is saying he did. 3 weeks later, one of the customers in the store said that this individual was showing customers pornography on his phone. So supervisor, manager, because, hey, we got this report, were you doing that? He's like, yeah, I was. pretty easy, even though it was well within the time, we're going to be able to defeat whatever kind of rebuttable presumption in that sort of thing. Now, most employees are not nice enough to give us that kind of stuff. So, best thing is address the issue when they come up. Another kind of good addition to your
Statute of limitations, is there a timing that needs to be considered?
Is there a statute, an applicable statute of limitations? Yes, it depends on what you're talking about. A statute of limitations is the time within which you have to file a lawsuit, either in court or with a governmental agency. The shortest ones tend to be about 6 months, particularly if you're dealing with a public agency. So like if I trip and fall out there on the sidewalk, I have like 6 months to notify the city of Livermore and the county of Alameda that, hey, there was this defective sidewalk out there. And that can also apply for certain OSHA complaints and things like that. Other ones, some have as much as a year, 2 years, or sometimes even 4 years. There's this thing called the Business or Professions Code 17200. I know, you guys love numbers, right? You guys, it's going to be a test later. And yeah, within that, it allows people to sue for unfair competition, which includes any violation of the law, and so it actually gets them up to like 4 years. But the good thing to know about that is record keeping. My recommendation and some requirements are keep your records, employment records, time records, hiring records, pay records, 4 years after the employee is no longer working for you. Don't have to be in physical form. You can scan them, make sure you have backups, but keep them for 4 years. Just nice, easy rule, 4 years. California Family Rights Act is a law in California, like the Family Medical Leave Act. You may have heard about it. It allows you to take time off of work for a serious or chronic medical condition, including your own, or to bond with a new child, adopted or newly born. The California Civil Rights Division now has they've had a pilot mediation program. If an employee brings a complaint about California Family Rights Act to the California Civil Rights Division, it gives an opportunity to do an early mediation for free through their services. It's no longer a pilot program and now applies for anybody with that type of violation. Very helpful. I have found, I'm a big fan of mediation. I'm a big fan of people sitting down and having a conversation before it gets expensive, because sometimes we can make small adjustments. So I definitely recommend participating in that should that type of situation happen. The nice thing is it does hold the statute of limitations, so you file the claim and we do the mediation, you're not going to have to worry about I have to run in and file a lawsuit real quick, because you kind of put a pin in that statute of limitations. It is really only for the California Family Rights Act, but the California Civil Rights Division, as well as the Federal Equal Employment Opportunity Commissions, both have mediation and conciliation programs for just about any of the claims under their jurisdiction. So it is an opportunity to be able to resolve things, hopefully early. Federal law also adopted the Pregnant Workers Fairness Act. It's similar to what we already have, and it kind of tailors on what federal law already has. California already has had the Pregnancy Disability Leave Act, which requires employers to provide time off work and other workplace accommodations. We also have the Fair Employment and Housing Act's disability discrimination laws that require accommodations. Some of the ones we're familiar with, dealing with pregnancy, time off for medical care, being able to sit or stand, being able to take more frequent breaks. What the Pregnant Workers Fairness Act does kind of codifies that and creates some pretty strong presumptions. We have to provide accommodations to persons who, because of pregnancy, need some modifications in the work. This essentially says that there's these virtually all cases where these are going to be reasonable accommodations. You know, being able to carry and drink water, giving them additional restroom breaks, being able to sit and stand as needed, and breaks for eating and drinking. I don't know any employers that would ever deny somebody that, but apparently they are, because the legislature said we need to make a note. Now, it's not to say that it's always going to be possible. So, for example, if I'm an airplane pilot, maybe I can't stand up as frequently as I might need to. So there might be things, but that's going to be a pretty rare exception. Those are going to be almost guaranteed that they're going to be a reasonable accommodation. It also kind of clarifies under the federal law for temporary suspension of certain duties is a reasonable accommodation. As a California employer, this is actually nothing new. That's something we've known all along. You know, if for a while, okay, you're pregnant, I'm not going to make you mix the ammonia and bleach together for a while. That may make sense. You can't do that? Or I'm not going to have you cleaning out your pregnant, so I'm not going to have you cleaning the cat litters. You know, things that like maybe we have to modify those, even if that's essential function of the job, temporarily we're going to change it. A couple of few cases that I think are important to talk about. The Bailey versus San Francisco District Attorney's Office is a recent case that I guess is surprising and not surprising. Talked about sexual harassment prevention, which also applies to racial harassment. The law, if you do that training, you learn that sexual harassment or racial harassment can include a single incident or a series of incidents. It could be severe or pervasive enough to alter the terms and conditions of employment. Typically, when I'm doing that training, I talk about, well, severe. It's, hey, I push somebody in the back of the room and I physically assault them. That's really severe. Versus pervasive might be, okay, it's not big, every day you show up, I call you some nickname related to your hair or your dress or something it's odd, uncomfortable, it's gender related. It's not severe in and of itself, but over a period of time it's a problem. So it's pervasive. Well, in this particular case, the employee, there was a single racial slur. They used the N-word one time. She didn't complain about it initially, but later on did, and nobody really did anything about it, and she filed a lawsuit. And the court had to ask, well, is a single utterance of a highly offensive word that has deep racial connotations, is that enough to qualify as discrimination or harassment? And California Supreme Court said yes. Now, they didn't say in this instance it was harassment, but they did decide that even a single isolated incident, a slur such as that, is enough that could qualify as sexual harassment or racial harassment in that particular case. So it's really a codification of something that I've kind of been teaching, but it really kind of hones in on the importance of training people on what to do what is our policy, how do we enforce it. The other big one is this Naranjo versus Spectrum Security Systems. This has actually been a somewhat tortured case because it's gone up and down to the Supreme Court, I think three different times. I kind of geek out on it a little bit just because it's I like wage and hour stuff. And the question is, what was compensable time? In this case, I drive to work, I have to go to a security gate, I have to show them my badge in order to get onto my premises. I then have to drive from the security gate to the parking lot, and then from the parking lot I have to walk in and I have to get to my actual office space. So the question is, at what point in time do I get paid for that? Because there's this thing called the Portal Act, which generally says my commute to and from work is not compensable. That's just part of me getting there. But there's a certain amount of control that we got there. So in this case, the time I spent at the gate, waiting in line and getting my badge scanned is compensable, because that's for the employer's benefit. The time traveling from the gate to the parking lot is not, because I can park wherever I want, I can drive however I want. And the time that obviously I'm on the premises where I can't leave is all compensable. So that's going to create some really crazy little, here's your time clock, okay, now you're through, clock back out, go back through. Thankfully there's not physical time clocks anymore. It really goes into, or it's a good reminder that you have to pay employees any time that they're under your control. We've had similar cases. I think Apple had a policy that they would search people's bags on the way in and out, the employees. That's compensable time, because the employees have the subject to that. But the time that I have to walk, necessarily from the time clock to, from when I walk in the front door to the time clock is not compensable. it kind of flips back and forth a little bit, but the general rule is, if they're under your control, you have to pay them. Yeah.
It's my understanding, if I'm correct, that when someone is doing hiring paperwork, that is considered compensable. So like not the offer letter, but then they're filling out the I-9 and all the hiring paperwork. A lot of times people have them do that ahead of time, but they don't realize that starts the clock of them being.
Yeah. So when you hire somebody, there's all sorts of paperwork. Usually you've given them an offer letter ahead of time or an employment agreement. But the I-9, the W-4, the DE-33, 5, 6, 7, whatever it is. Yeah. All those things. I remember one of my first time I ever got an employee handbook for an employer. They gave it to me. I sat down and read it. And yeah, I got to get paid for that time. There's actually some talk about whether or not employees should get paid for interviews. And it's stemming from situations where people are getting called back for multiple hour-long interviews where they're having to take time off of their job. And they're saying, look, I'm happy to come in for a second, third, fourth, fifth interview, but you're going to need to compensate. There's no laws that say you have to do that. I don't know of any efforts to change that, but it is also something that to be aware of in that interview process. I kind of like the Tesla version of the interview process. They do a Zoom meeting with 200 people, and it lasts several hours. And their candidate list gets shorter and shorter by who logs off. So, you know, it's nothing. Some other cases that are coming up, the California Civil Rights Division is changing or going to propose some regulations about AI-based decisions. Companies are starting to use algorithms that, okay, we've got 100 interviews or we've got 100 different people that have applied. Weed through all these interviews and all these resumes, and let's figure out which ones we want to do. Well, what have we learned about AI? Well, it's designed by people who predominantly male Caucasians, and using data that's been created by male Caucasians, there tends to be a sway towards male Caucasians. What do you know? So how do we address that? And so it's going to be interesting because everybody has their own implicit bias, right? And I go into this based on how I was raised, how I've been treated, and how I treat others, and I go into any of my interactions with all of you with that in mind. So you cannot get rid of that implicit bias. The best we can do is be aware of the fact that we have that, so that we can look for ways that how is my implicit bias, my unconscious bias, how is that impacting how I'm receiving you, interacting with you, perceiving you. There's actually an ability to maybe get rid of that through AI, to actually get rid of that implicit bias, because you strip out, if you can strip out all the data that identifies people by how they are. Can we create a system where all resumes are gender neutral, that do not give dates at all for when their education was to indicate what their ages might be, to get rid of their location-based data that might indicate poverty levels or non-poverty levels. And so I think there are some really great ways that we could use AI to eliminate some of the biases that we can't have. We just have to figure out a way to program our bias out of that. I've been reading a lot of Isaac Asimov books, so I don't know that it's really possible. iRobot, things like that. Another big one that I'm looking out for is on rounding practices. You clock in, like, okay, you're supposed to start at 8:30. You actually show up at 8:27, and you clock in at 8:27. Do I pay you at 8:27 or 8:30? Well, what about when you show up at 8:35? Which do I do? It used to not be a big deal because it was people would report their hours, and it is what it is, and it was not a big issue with rounding. But now, particularly with technology, where it's easy, I can track you to the second. There's an issue, because the California Supreme Court has said that you can do rounding, but it's kind of at your peril, because if you do the rounding and it turns out you didn't pay them for every minute, then you're liable. So you spend more time doing statistical analysis to prove that they weren't underpaid, then it doesn't. So the bottom rule is, if you really want a round, have them write in their hours and let them, just pay them for whatever hours they put down there. Most people naturally, if I show up at 8:27, I'm going to put 8:30. If I show up at 8:35, I'm still going to put 8:30. And you're going based on what they're recording. If you have a time tracking method that allows you to beat it the minute, pay them by the minute. That's what I do. I just, Google Sheets makes it really simple to just calculate out exactly to the minute, and you just pay them for that. The unfortunate next step is going to be to the second. I don't know where they're going to draw the line, but I can definitely see that happening. I thought at the minute was like, really? The minute? Because in federal law, there's this thing called de minimis time. And it's such a small amount, and it's a fractional amount. And it is a fractional amount, but those of you who are a fan of Superman 3 with Richard Pryor, he was a programmer and he got this paycheck. He's like, well, I only got, what's this half-cent thing? And he figured out a way to program it. So all those extra half cents got paid to him. Well, the first check was like $14 million. It's like this huge amount of dollars, because if you've got a large corporation, those little cents can add up. So if we can be precise, I would say be precise. So we're going to see what's going to happen. And if you have a neutral policy, it says it's neither weighted in favor of the employer nor in favor of the employer. Yeah.
For exempt employees, have you seen any laws or cases about actually overwork, to the effect that, basically we can be working on our computers all the time,
Mm-hmm.
remote work. So, I'm sure many executive directors and other leaderships actually put in way more hours than are really compensated for. So,
Yeah.
Is that coming up at all?
Yeah, so the question is whether or not with exempt employees who are paid a salary, are there issues about them being overworked? I mean, technically, a salary compensates you for all hours worked. If you want to work 168 hours a week, then that salary is paying you for that. And it's a matter of, how much time do you want to spend. Where I have seen the issues come up more frequently is actually with vacation. So there are very few times when you can reduce a salaried employee's weekly salary without losing the exemption. So to be exempt from overtime, I have to get a weekly salary of a certain amount, 2 times minimum wage in California. And I have to spend most of my time performing exempt duties. If I don't guarantee that salary, if I don't pay them that salary because they didn't work a day, they are no longer exempt. Certainly for that week, potentially you may lose the potential all the time, because if you do it more than once. If the times when you can deduct are if they're gone for sickness and they've already exhausted all of their paid sick leave. Or if it's that California Family Rights Act time, likely pregnancy disability leave act time, or family medical leave time, because those times are specifically unpaid. The difficulty with the vacation is I'm on vacation. I get 3 weeks of vacation and I check my email. Well, I've just performed work. So technically you may have to pay me for the whole week. Or, and you see the other kind of converse is not with the exempt employees, but the hourly employees of, hey, you have to pay me for every hour. You just sent me a text at 6 o'clock at night telling me that I got to show up to work at 9 o'clock. Okay, you got to pay me for that. Or I looked at my emails, and oftentimes those aren't reported out. So I am starting to tell my clients, for the hourly employees in particular, tell them, do not perform work after hours. When you clock out, that's your time. If I send you a text, you do not have to look at that the next day. If I need to tell you something for that, I will pick up the phone and I will call you. Otherwise, just don't work. Don't look at your emails. And some even, like, you could use a system that turns that, they can't get the access outside of those hours. For the executives, for their vacation, I would tell them, don't work on your vacation. This is your downtime. Please don't work. I know you're guys like, have you met me? I've never seen Kathy not work.
Because it's kind of based on an old, we didn't have access for 24 hours, right?
Yeah.
So
It was an
now we
old
do.
model. Yeah, now we do, and you can be hit up at any point in time. I think there are some things that you can do with the vacation model.
Yeah.
And to kind of be safe, first of all, a lot of employers like these unlimited vacation plans. No. There is no such thing as an unlimited vacation plan. Because I guarantee you, if your employee comes and says, look, I'm going to take 7 months off vacation, I'll be in Aruba, I'll see you when I get back, you're going to say no. And the difficulty is because employees can use vacation time for certain unpaid leaves, 12 weeks of SIFR leave, 4 months of bonding leave, 15 days of bone marrow transplant leave, all these different leaves. You could have an employee who says, okay, I'm going to take my leave for my 4 months of pregnancy disability leave, and it's paid. And now I'm going to take my 12 weeks of bonding leave, that's also going to be paid. Now you've got somebody who's not working for 7 months, and you have to pay. So that's problematic. And if you were saying, well, yes, you can use it for any amount of time, but you just can't use it if you're on this protected leave, well, now you're treating the protected leave differently. There are ways to get around that. I just overall think it's a bad idea. Give them a certain amount. Because the other thing is, employers sometimes think, oh, we're doing this as a favor to you. We're making it easier for you. Because now you can take more time. The reality is, the studies are showing people with unlimited vacation take less vacation. Because if you give me 3 weeks, I'm going to take 3 weeks. If you don't, I'm always wondering if I can or shouldn't. Yeah.
So if someone has them on their vacation, do you not owe them anything when they leave?
That's the theory. The theory is because it's unlimited, there's nothing accrued, so I don't have to pay when you leave. The problem is because there are going to be limits, and there's a case that has said this, because they did say, okay, you can't take more than 4 weeks, or you can't take more than X. That puts a limit on it. That now means it is a benefit that has to accrue, and you have to pay that out on termination, and you've deprived yourself of putting the limit, the actual maximum accrual limit on. So it's really kind of bad. Yeah.
How about load time for salary?
How much what?
Load time. Load time.
Like comp time? Okay, so there used to be, technically still is, there's a statute in California that says you can use comp time where, hey, I'm going to work overtime. Like I work 2 hours of overtime. You're going to pay me at the straight rate, but I'm going to be allowed to take that overtime, that time off in another week or at another time. The labor commissioner, incorrectly, in my opinion, they don't ask me in my opinion, but it's still. So there's a labor code section, and then there's a section very similar for public employees that says the same thing. Public employees have different rules that apply. Legislature did away with the public employee portion. The labor commissioner decided, well, since that is no longer valid for public employees, the labor code section that says you can do that's no longer valid. It's not true. It's still there. It's still on the book. So technically you could have it. The mistake people make is when you do the comp time, they have to be able to get 1.5 times. So if I work 1 hour here, I need to be able to take an hour and a half off later. There's a different concept called makeup time, where if I, as the employee, I need to leave early on Friday because I got a doctor's appointment or whatever, so I'm going to work an extra hour Monday, Tuesday, and Wednesday to make up for that. Is that okay? You can do that and not have to pay overtime. But there's requirements. 1, should be in writing. 2, it's the employee's option. 3, they have to work and make up the time in the same work week. So it can't be, oh, I took the time off on Friday, so I'm going to make it up on Monday, Tuesday, Wednesday of the next week. So it's pretty limited that we can actually use that. That does get me to the Q&A portion of our wonderful part. So, I know we've been asking questions all along. I'm happy to answer questions. How much more time do we have?
You have 20 minutes.
Yeah, well, we want to wrap up at
Oh, okay.
5 minutes till. So like 15
Okay, so wait,
Well,
right now was the Q&A
You have 5
time?
minutes until your 5-minute warning.
Okay. So anything that I've gone over or any other questions that you have, I'm happy to answer. I mean, you got me today, so take that. Yeah.
So some of these things are kind of really scary, especially when you talked about trying to get people to not work when they shouldn't be working, and particularly for nonprofits because kind of you're passionate. And you
Yeah.
do. So if we have these policies as the employer in our handbook and say this is the company's position and the employee signs off that they've read the handbook and understand our policy, and then they go and try to sue later because they checked their email or responded to a text, that's at their volition. And then they, for some reason, become litigious. I mean, how protected are we if we have that policy?
That is a great question. So basically, we're diligent, we have our policies, we tell people to clock in and out. They've signed that policy, but nonetheless, unbeknownst to us, or maybe knownst to us, they do some work without putting that on their time card. How much liability does that create for us? A couple different things. I can't say there's no liability. There was a case, Jong versus Kaiser Permanente, I believe. This gets pharmacy in Kaiser, where Kaiser had a policy that says we have to pay you for everything. They got sued because they weren't. And so they made it really clear, no, we're serious. You have to, no working off the clock. And this particular pharmacist or assistant pharmacist needed to get things done, and so he was just working a lot and not reporting the time. In that case, the court actually said, because you didn't report it, and you knew that if you reported it, you would be paid, those are not considered hours worked, which is actually a pretty surprising decision in California, quite frankly, because the definition of hours worked is very broad. It's any time the employee suffered to work, permitted to work, or they're under your control. So the control, that was that driving in, going through the badging, right? They're under the control, even though they're not performing work. If I allow you to do the work, like I'm saying, yeah, you really shouldn't work. I really need you to get this done. No, I'm not going to be able to take advantage of that. But if I have a policy in place that says, look, you need to record all of your hours worked. We will pay you for all the hours worked. Do not work off clock, period. And somebody works off clock and you have no reason to know they were doing so, we've got at least a defense. And this is also where that, I mentioned that POG audit or the wage and hour audit can really come into to benefit. One of the new requirements that I'm suggesting for my clients or suggestions is, so when people get their handbook, they're used to just sign the confirmation of receipt of the handbook. Then there is a requirement of the sexual harassment prevention policy. We want to make sure everybody gets it. So now they're also signing, okay, I received the sexual harassment prevention policy. We've got that as well. We're now recommending, and Cal Chamber's recommending as well, that they actually sign receipt of the timekeeping policies. So that they're actually receiving it, saying, yes, I've received all the timekeeping policies. And in there it says what the rest breaks is, what the meal breaks are, where they should report if their time record's inaccurate. So at least it gives us that kind of a defense. And it gives us the defense and it gives us that opportunity to say, look, we've been training our managers how to do this. And I think it's also being consistent. I have one client that they have that as a problem. Every 6 months, they send out a reminder, hey guys, can't work off the clock. Please report all your time. God, it's scary. Take your rest breaks, take your meal breaks. By having those repeated communications, by training the supervisors to communicate that to the workers, we at least have a defense that, look, we did not require you to, we did not suffer you to work, and nor did we even permit you to work. In fact, I'm going to write you up because you worked off the clock in violation of our policy. Okay.
The first one is, could you put a quiz at the end of the handbook? How many hours can you work or should you work off by to have that, back that up? And two, can you talk about employees with email on their phones?
Yeah. So can we do a quiz at the end of the handbook to make sure they understood it? You can. I don't think it's against you.
Would it be helpful?
I think it would be helpful. I think it actually is helpful for your supervisors. What is our policy for rest breaks, meal breaks? Or, how do we make that consistent? I think that's a great idea. Maybe if there's a fun way to do it. The acknowledgement is probably the best you can. And then the other part of the question was?
Email on phones.
Oh, email on phones. Yeah, so that's the difficult thing. So how do you prevent them? One, At the very least, you want to communicate, hey, look, we're allowing you to get access to email on your phone, or you're working from home. That's the other thing. How do we control somebody who's working from home entirely? These are our general work hours. You need to clock in and out. If you're performing work, clock it. Don't perform work. Take your time. Spend the time with your family. Be specific. Have that kind of an environment. Some people, you could go, and the companies, you could go so far as, no, we're going to set it up in our system. Like I know if you go through your Google servers, you can set up so that every day at 5 p.m. it automatically says, I don't look at emails after 5 o'clock. I'll see it. I'll look at this again when I get back to work at 8 a.m. And you can turn off notifications. There are things you can do that. Encourage people. Hey, look, if you got an iPhone, you got this little focus thing you can put on there, and you can so it won't tell you about emails. You can still allow it so you can get calls from your family and people in your contact list or however you want. Educating them. Look, this is really your time. Unfortunately, you can't force it. But the more you can encourage them and show that we're encouraging people, the easier it is to be able to. Yeah.
So for learning and development records, they've gone through the training. Are you yes, no, that they did it, their attendance, the date, and that's it? Or is there anything else the legal group's looking at?
Yeah, so I'm, some people have checklists of all these are the different trainings.
Yeah.
I think that's great. I think for certain more important policies, we probably want them to sign those policies. Sexual harassment prevention. Now I'm doing this kind of wage and hour policy. Some people, if you're working with elderly or disabled people, you're going to want them to sign things about elder abuse and mandated reporters, things like that. If you're in HR and you're working with minors, you're mandated reporting.
And they don't have to be in any other language, right? That the onus is on the person to read it in the language, which is most likely English.
Well, I would say if you know this person doesn't read and write English, then you really should figure out how we're going to get that translated. And if that means, hey, your so-and-so speaks, your cousin speaks it, then they sign something saying they translate it. If you have a certain number of your population, some of the statutes require it to be in other languages.
10%.
10%?
If you have 10% of your work population speaks a different language as their first language, you have to have all kinds of forms and handbooks and training also available in that language.
So it doesn't suffice like Google Translate, they can look at it.
Oh,
As long as you have, if
I
you
mean,
have
You
under
can
10
use Google Translate.
Well, I mean, that's like,
It's-
because I think understanding beyond just being there and signing it is really what we're
So
trying to
one of the
do.
things, how does that person communicate with their supervisor?
Yeah.
If that supervisor is bilingual,
Yeah.
then they can sit down, they can have a conversation. Let's go through it. And that acts as a training, and then the supervisor signs, I'm fluent in English and Spanish, and I went over this with them, and that is kind of the next best. I see another hand up? Yeah.
So you talked about not having an unlimited vacation. What about PTO for exempt employees?
PTO and vacation are the exact same thing. The distinction used to be there is paid sick leave and there is vacation. When you combine the two, this is how I've always thought it, when you combine the two, it becomes PTO. I usually prefer to have PTO and vacation separate. PTO and vacation is a wage. Paid sick leave is not. Paid sick leave is a protected leave. Vacation is not. If I give you 3 weeks and you can use it for paid sick, and I'm using that for your paid sick leave, I don't know if you're taking time off for a protected reason or not. I don't know if I can say, no, don't take that. Because you can say, no, I have a doctor's appointment, and now all of a sudden I'm in violation. Plus I'm ending up having to pay out more. I just think it's safer to keep them separate. Yeah.
Also, one of those, you have to pay out when they leave, and the other one you don't have to pay
Yeah,
out.
paid sick leave you do not have to pay out. That, vacation and PTO is a wage. Paid sick leave, they don't get to use it, and they don't get paid it unless they are sick, or one of the other 13 reasons that they can use paid sick leave.
Yep.
Family member being sick. Now there's a designated family member, but the definition of family member, by the way, now includes a designated person. So both for California Family Rights Act as well as paid sick leave, the employee can say, at the time, my Uncle Louie, not really my uncle, he just hang around my house, kind of creepy, but I gotta drive him to the hospital, so he's my designated person. And they can use the paid sick leave. that designation is good for 12 months. So they can't say, okay, well now it's my Aunt Val too. Also a little creepy, but not as creepy as Uncle Louie. If there's anybody named Louie who's an uncle, I apologize. I don't. You got a question?
Yeah, thanks. I was just about to hire for the first time.
Don't. I'm sorry.
Just do it yourself.
I'm wondering if you can discuss best practices for dealing with applicants who you're not interviewing in terms of response and in terms of record keeping.
So how do we deal with applicants that we're not going to hire? How do we say we're not going to? So one option, it kind of depends on what your product is. Like sometimes there's just buttons you click like on Indeed.com, you just kind of, you can set out to, sorry, you weren't chosen at this time. You can do that kind of the same, thank you for your interest. You weren't chosen at this time, but we'll keep your information on file if the need arises. You could say nothing and just hope they go away. I'm not a big fan of having to respond to 200 applicants. But so it kind of depends on what stage. I think the more important part is making sure that the applicant process is as neutral as possible. So we're not asking questions that we shouldn't. Like sometimes it's just like we've hired, it's like, we're not even going to call this person in for an interview. We were looking for a legal secretary, you're a short ordered cook, no thank you, we're just not going to do it. Others, now we've got our pool and now we're going to bring them in for interviews or we want to, even if it's a quick interview, what questions are we asking? You're not asking about age, race, sex, national origin, etc. Age includes things like, oh, when did you graduate high school? When did you graduate college? Those are indications. Where did you grow up? I wouldn't be asked that. I would not be asking about family status. I would be asking non-personal questions. I would be asking questions about this job. Tell me about your experience with this. That are really kind of designed that way. And that is also true about your job announcements. Making sure that your job announcements that you're putting out there is neutral. Keep in mind also background checks. I don't know if anybody does criminal background checks. Many times you're limited as to when you can do that. You can't do it until after you do a conditional offer of employment. There are certain exceptions. I think that only applies if you have 5 or more employees. But my general rule is if you're going to do a background check, and if you are at all inclined to say no, call me. Or check the resource, because now there is some specific language that you need to include. And if you're in the county, unincorporated counties of Los Angeles, there's even heightened requirements. Yeah.
Is there any kind of best practice for this if you have internal applicants?
Best practices for internal applicants. So we have a position. Are we required to? Should we open this up to internal versus external? First of all, you're not required to by the law. You as an organization have to decide, do we want to open this to internal applicants first? Do we want to offer it to them at all? And if so, is that process the same? It's probably going to be different than if you're hiring from the outside because you already know what their skills are. But how do we decide, what information do we need from this person to really decide if they're right for that? Do we need a supervisor approval or recommendation or just a statement, hey, why do you think you'd be a good choice then? So
what about like if it's the application, it's open to anybody, and so you have people from the outside and then you might have 1 or 2 internal applicants that you might not have thought of, but they may or may not be the right person for the position. So I don't know, it just seems like you can open up some
if we want to have, we want to allow people to apply and we're getting applicants from outside, inside, do we give them preference, do we not? Whether or not we give them preference is, and really even if we allow them to apply, is up to you. I'm kind of the opinion, if you're going to let the public apply, why wouldn't you let your employees apply? But that doesn't necessarily mean I'm going to give them preference. Just like we know what their skills are, we know what their skills aren't. So it may be like we're not going to hire them because it's not a good choice. I will tell you, I do think there are some perception issues of, hey, I've already been doing a lot of these duties, why are you hiring this other person? This other person is insert protected characteristic and I'm not, or vice versa. I think it's because of some protected reason or because I complained about this or because some protected activity. So I think there is that risk. But if you're clear on what the requirements are and you're focusing on what the skill levels are, I think that's important. One thing that I always like is job descriptions. Starts with your job announcement, but also your job descriptions, having those things that really accurately just describes the job, but also what are the other things that we need? The ability to communicate effectively, be able to sit, stand, walk, lift 100 pounds, see long distance, short distance. What are all those requirements that we may not have thought about when we think in the abstract or whatever it might be. So the hook is coming out, pulling me out, it appears. Thank you very much. If you guys have questions, feel free to reach out, but thank you for the opportunity.